Good morning, everyone. My name is Crista Cuccaro. I'm a faculty member here at the School of Government, just down the hall from Rebecca, who you just heard from. I want to say first, apologies for my voice. For those of you who have little people in your life, you may know that the start of school also means the sharing of germs. And so the cold that came home found its way to me. Luckily, I think I'll be able to make it through the time that we have together. Got some cough drops and water at the ready if needed. But again, my name is Crista Cuccaro. I'm a faculty member here at the School of Government. I am also a lawyer, and I specialize in public procurement and contracting, both state law and federal rules, which is what we're going to be spending time talking about today. So I want to go ahead and get started because I know that we have about an hour and a half here together to talk about procurement and contracting. That's what we're going to focus on in the first part, just the general requirements. And then we're going to get into the cross-cutting requirements. So again, part one, we're going to talk about procurement by subrecipients, and that is you all in local government, right? Rebecca talked in the earlier session about how the state of North Carolina is the grantee of the CDBG-DR funds, and they are passing those funds along to you all. And so in local government, you all are what we call subrecipients. And what that means is the requirements of the uniform guidance, what Rebecca talked about, what I'll be talking about, flow down to you. So we'll be focused on procurement, just the procurement methods, the procurement process here in part one. Then you're going to break for lunch. And then after lunch, we're going to talk about cross-cutting federal requirements. And Rebecca touched on those, but those are sort of the additional requirements that would apply to these CDBG-DR funds that we don't necessarily find in the uniform guidance, although some of them are in the uniform guidance, but they might be located in other places in federal law and regulations. And so they apply here to CDBG-DR, and you need to know them. And that's what we're going to focus on in part two of today. So a two-part series here. And let's go ahead and get started with part one. So for part one, I'm going to give you a refresher on the regulatory landscape. Rebecca covered this in some detail, but I want to kind of orient you before we jump into the procurement process, just to remind you of sort of where we find ourselves among these codes of federal regulation, all of these public laws, statutes, state law, and the like. Then we are going to move into the procurement process. How do we determine what procurement method we're using? And then to follow, what procurement process procedures do we use for that specific method? And then last but certainly not least, I want to touch on exceptions to competitive procurement. So we'll start here with this refresher on the regulatory landscape. So where are we? We find ourselves sort of among all of these different regulations, right? So we're going to be talking, like you see at the top here, about the uniform guidance, which is Title II of the Code of Federal Regulations, Part 200, and the cross-cutting federal requirements. We also know that these disaster recovery funds are regulated by 24 CFR Part 570. We also know that the universal notice specifies some additional or alternative requirements as relates to this specific tranche of funding. And then we, of course, have our state statutes, right? So everything that I mentioned before that was federal, but we also have our state laws, which you can't lose sight of because you also have to comply with state law, even if you're using federal funds. So we find ourselves, boom, right here in the middle, all right? So I'm going to talk about each of these in a little bit more detail on some upcoming slides, starting with the uniform guidance, kind of moving in a clockwise direction. So I have this title here, One Rule to Rule Them All, which for those of you who are Lord of the Rings fans may sound somewhat familiar. But the uniform guidance was intended almost, I guess, over a decade now, as a rule promulgated by the United States Office of Management and Budget to aggregate, combine all sorts of different memos and circulars that governed procurement with federal funds and kind of put them all in one place with the intent of having uniform guidance, right? We don't have to look at all these different documents to figure out what rules to follow. We can look at the uniform guidance. And so that happened in 2013, and the uniform guidance has been updated over time. The Office of Management and Budget has made changes, most recently as of October 1st of last year. So I say one rule to rule them all question mark because we already know, I've mentioned to you, that we have additional cross-cutting federal requirements, and federal agencies will sometimes make changes to the uniform guidance. Rebecca touched on it earlier, how HUD can make changes to what is found in the uniform guidance. She showed you that regulation, 24 CFR Part 570. And so it's not as uniform as we might want it to be. We can start with the uniform guidance to understand how we need to make use of federal funds, but we're going to have to look to other places like these cross-cutting federal requirements that we find in other statutes and to federal agency guidance. So again, not as uniform as we like, which is why I have that question mark there, but a really good place to start. Rebecca mentioned that many of you are probably already familiar with the uniform guidance due to your experience with ARPA, but I'll remind you that we find procurement standards in the uniform guidance, subpart D, section 200.317 to 327. Now, 200.317 applies to states and allows states to follow their own procurement process, but local governments, you're not the state, and therefore you have to follow 318 to 327. Now, as the grantee of the CDBG-DR funds, the state does have some discretion to tell you exactly how they expect you to procure. And so there's some language that we find in the universal notice about that. But in the absence of any of that at this particular moment, we're going to just use the uniform guidance as our guidepost for procurement. And so that is our first part of our regulatory landscape, the uniform guidance. We also have these cross-cutting federal requirements that I've mentioned several times already and that I will be talking to you about in great detail this afternoon. These are things like Davis-Bacon and related acts, Section 3, Uniform Relocation Assistance, Section 104D, debarment and suspension, the Byrd Anti-Lobbying Amendment, and several others. But we can sort of think of these as labor standards and relocation requirements, and then all of the other contract clauses that are required by the uniform guidance. One quick note here that I have highlighted in red is that the Build America, Buy America Act does not apply to CDBG-DR funding. So without getting into too many specifics, the Stafford Act, which is sort of regulates emergencies, emergency declarations, specifically says that this type of disaster recovery funding does not have to comply with BABA. I want to note here, and I'll remind you again, that it could be the case that you have a project that involves CDBG-DR and other federal funds. So you need to be sure that you know what federal funds might be used in that mix, because it could be the case that those federal funds do have the BABA requirements attached to them, right? And so then you're going to be needing to look at the particulars of the products, materials being used for that infrastructure project, and making sure that they are produced domestically or comply with BABA, because we know that there's some waivers under BABA. So a bit of a departure there, but I just want to remind you that BABA does not apply to CDBG-DR funding, but depending on the mix of funds used eventually for a project, you may need to consider BABA. All right, moving along in our landscape, we have the CDBG program administrative requirements. So in 24 CFR 570, 489G. The HUD tells us through its regulations that the state has to follow its own procurement policies and procedures, and the state has to establish program policies and procedures for units of local government based on full or open competition. And it could default, like I said earlier, to the uniform guidance. And I think that that's very often what happens. But that's a decision that's yet to be made as Commerce is developing its policies. So we're going to presume uniform guidance and move forward with that in mind. We also have the universal notice. Rebecca talked about this. This is the pre-appropriation notice from HUD that governs the process, procedures, timelines, waivers, alternative requirements for the use of those CDBG-DR funds. And CDBG-DR grants are typically subject to kind of the general CDBG regulations that we find in 24 CFR Part 570, but there is the ability to make modifications through that universal notice. The universal notice, of course, is lengthy, but most of its requirements apply to the state as the grantee, such as having a residential anti-displacement and relocation assistance plan, a RARAP, which I'll talk about later in some detail. Or another requirement that the state as the grantee is subject to is publishing contracts on a public website, contracts that are funded with these CDBG-DR funds. So there's a lot in there, but what I have done for our purposes today is review the universal notice and try to pull out provisions that might apply to you all as subrecipients in your procurement and contracting processes. And last, but absolutely not least, we have our state procurement statutes. So we find most of our procurement laws here in North Carolina in Chapter 143, Article 8 of our general statutes. These are laws enacted by our General Assembly that tell you in local government how to do public contracting. So we have our formal bidding statute, that's the first one on the list there. Then we have our informal bidding statute, second one on the list. And we have a lot of other statutes that govern particular types of contracting processes like construction and allow for variation from competitive bidding as well, which we'll talk about at the end today. I've got a note here at the bottom. You also have to keep in mind your local procurement policy. So we've talked about the uniform guidance, the Code of Federal Regulations promulgated by HUD that applies to CDBG funds. We talked about the universal notice. We've talked about state law, right? On top of all of that, you also have to follow your local procurement policy. And my guess is that if you're on the call today, you probably have a local procurement policy in place. It could be that that procurement policy is a little dusty, needs some updating. I've got some resources for you at the end of this particular presentation to give you some guidance on how to update your policies to ensure compliance with the uniform guidance. But you need to have a local procurement policy and you have to follow it. Upon a sort of audit, that is something that HUD will take a look at to make sure that you followed your local procurement policy. So if we have all of these different layers of regulation, right, how do we know which one to follow? It could be the case, right, that there's a inconsistency among the regulations, right? One of them says you have to do this for X number of days, but another one says do it for Y number of days. Which one do you follow, right? Those aren't the same number of days. You're going to follow the most restrictive rule, right? And the reason for that is if you're following the most restrictive rule among federal, state, and local procurement standards, then you will know that you have followed all of the rules. If you follow the most restrictive rule, you will have followed all of those rules. And I like to think of this as a birthday cake, a 3-layer birthday cake. So let me get some candles on there. And I'll describe to you what I mean here, right? So you can see, hopefully in your mind, this cake is taking shape, right? Now that I've added the candles. We've got our federal rules, our state rules, and our local policy on procurement. And so an example of where we run into an inconsistency on procurement standards is the minimum number of bids. So if we're thinking of our whole cake as procurement standards, right? We've got our procurement standards in this cake, and we've got our 3 layers. We're going to take the slice out of the cake that relates to the minimum number of bids. So we know, or you will know by the time this is over, that state law for formal construction projects requires 3 bids as a minimum in order to proceed with the procurement process. The uniform guidance isn't as specific. I think 3 is a general rule of thumb that people do use when they are procuring with federal funds, but uniform guidance isn't explicit that there has to be 3 for a formal construction project. State law is very specific. So this would be an instance where state law is more restrictive than the uniform guidance, and possibly more restrictive than a local policy. So if we're looking at this slice of cake that we've cut out on the minimum number of bids, we're going to compare how many bids do our federal rules require, how many bids does state law require, and how many bids does our local policy require. And we're going to follow the most restrictive rule among those 3 layers of regulation. So follow the most restrictive rule, a really important thing to keep in mind as we're talking today about the uniform guidance and other state law regulations. I want you to know in some upcoming slides I've highlighted for you where we find the most restrictive rule as between the uniform guidance and state law. So I have a kind of quick chart as a reference for some of the projects that we'll be talking about today. We also have more extensive resources on this most restrictive rule concept linked at the end of today's presentation. All right, so I'm going to shift gears now and kind of talk about all of this in the context of CDBG-DR. Rebecca mentioned earlier, she gave you some details on the types of programs that will be funded by Commerce using these CDBG-DR funds. So here on the screen, you can see the sort of the 5 categories, and I have grouped them into, I've sort of collapsed them into 3 categories for the purposes of this conversation on procurement. So we've got housing, infrastructure, and economic development. And one of the really critical pieces of information that you need to know when you are proceeding with a contract is, are we contracting here for services, and thereby we need to procure under the uniform guidance, or are we giving funding through a sub-award, and therefore we are dealing with a sub-recipient and we're not bound by the procurement standards in the uniform guidance, right? And Rebecca talked about this distinction between sub-recipients and contractors earlier. I've got some definitions here on the screen to sort of remind you what the uniform guidance says about a contractor and a contract versus a sub-award. And the uniform guidance also has a section, 2 CFR 200.331, that outlines for you how you can draw this distinction. And again, this is something Rebecca touched on, but it's really relevant for procurement because we need to know whether we are sort of under the procurement umbrella and we are procuring our contractor using the uniform guidance, or if we are passing along the uniform guidance requirements to a subrecipient. So I think for many of the programs that we are going to be talking about, you will be entering into a contract relationship, but certainly not exclusively. There will be instances where you may be giving funding to a nonprofit, or you may be sort of partnering with a developer on multifamily housing, and that's not necessarily going to be considered procurement. And so you can use this section of uniform guidance as a guidepost for helping to make that determination and figure out whether you need to apply the procurement standards of the uniform guidance. So let's take a look at some projects and talk about them with this distinction in mind. So if we're talking about housing, right, we may be talking about multifamily housing, kind of reconstruction, rehab activities for housing that existed. or new construction of multifamily housing, or we may be talking about the development, construction of workforce housing for purchase by LMI households. And so we know that the eligible applicants for those programs to do either of those types of housing projects are private developers, local governments, public or private nonprofits, and community housing development organizations or community-based development organizations. And so we need to understand the relationships behind the process to figure out, again, are we doing that procurement? Are we procuring a construction contractor ourselves and overseeing that contract, their construction of this multifamily housing? Or more likely, is it some sort of partnership or passing along of funds to an entity that is going to develop the housing, right? And so I did some research on how CDBG-DR funds have been used in other places and other programs to give you sort of an example of what we might be talking about in the context of a housing program. So here we have an apartment. This is South Rice Apartments in Houston, Texas. And the city of Houston used $12.4 million of its CDBG-DR funds towards a $33 million construction project to end up with this LMI housing. And so this is a context, right, where this was very likely a partnership where these funds were being sort of passed along to the developer. The city of Houston was not, they don't own this project, and they are not necessarily involved in the construction oversight. It was just these CDBG-DR funds being leveraged for the overall construction project, perhaps in tandem with other programs like LIHTC, right? And so here, I think this would be an instance where we don't have a contractor relationship, and this is not something that's going to be subject to the strict procurement standards that we find under the uniform guidance. Now, I want to make one other note here on this example and the other examples that I have for the other programs, which is I do not want to, these are sort of for illustration purposes, these examples. I don't want to make any assurances to you that this type of exact program or project will be funded by Commerce once it gets ready to issue awards for the multifamily housing. So these are just for illustration purposes, but for our conversation about procurement and our conversation about subawards and subrecipients, I thought that this would be helpful to take a look at these projects. The next category of programming that Commerce is going to be funding is infrastructure. And infrastructure is a really big category. It can include things like road improvements, water, stormwater, wastewater improvements, all sorts of projects typically that are publicly owned, right? You'll see here in terms of eligible applicants, local governments are the eligible applicants in the mid-counties for these infrastructure funds. So what might this look like? In Pine Grove, Pennsylvania, there was an area that had consistent flooding. And so the community used CDBG-DR funding to sort of create this natural wetland. They did some grading and changing of the topography of the land to create this wetland to collect water so that it would mitigate some of that flooding in the future to residential and commercial properties. So in this instance, they used over $2.5 million of CDBG-DR funding to create this floodplain, this naturalized floodplain area. So thinking about this example from a procurement perspective, this would be a project where the local government here, Pine Grove, PA, as a subrecipient, would be procuring the services of a construction contractor who's going to be doing that grading, putting in place everything that's needed for this naturalized floodplain area. And so we're going to kind of focus on some construction in some upcoming slides when we get into the procurement process. But under the infrastructure category, I think that's going to be the most procurement-heavy category for the work that Commerce is funding using the CDBG-DR funds. And then lastly, we have economic development, economic revitalization. And so we know that these projects are going to carry out revitalization activities in commercial areas, can include some of the things that you see here on the list. So acquisition, demolition, rehab of commercial structures, assistance to small businesses for rehab and improvements, facade improvements, and mixed-use projects that include commercial and housing components. Eligible applicants here are local governments or nonprofit organizations. So an example of how CDBG-DR funds have been used for economic development in Puerto Rico, following a series of storms, $3.3 million of CDBG-DR and FEMA funds were combined to reconstruct a public plaza in their kind of central business area. And so, again, this is an example for illustration purposes. I want to remind you that this is not an assurance that a similar type project will be funded by Commerce. But in that instance, right, this is a public plaza, publicly owned, and so these improvements would have been handled under a construction project, a construction contract, and therefore subject to the procurement standards that we're going to talk about today. All right. Before we get into those procurement standards, I want to remind you of a few things. First, you have to have state law authority to do anything with federal funds, right? Rebecca talked about this, but I think it bears repeating that you have to make sure before you spend any of that federal money that you receive that you also have state law authority to do whatever activity it is that you've applied to do. And so we have lots and lots of sources of authority. I've thrown a few here up on the screen for quick reference, right? We have Chapter 160A that governs our municipalities, Chapter 153A that governs our counties. We find in Chapter 160D our Community Development Statute at 160D 1311. In Chapter 158, we find economic development statutes. So we've got 158-7.1. And of course, we have in the background of all of our laws, the North Carolina Constitution, which reminds us that we need to have a public purpose when we are undertaking activity as local governments. So all of this is really important to keep in mind and make sure that you have the authority to do what it is that you have applied to do. Another reminder, choice limiting actions. Rebecca did mention this as well, but again, it bears repeating that you don't want to do any activity, sort of get it out ahead of the process, particularly the environmental review process, and undertake activity that is going to limit your ability to have flexibility around that environmental review process. That's really the goal here with choice limiting actions. And so, excuse me, I have some examples here of choice limiting actions, but like Rebecca said, don't move dirt until we've sort of gotten to the right place in terms of the environmental review. Okay, so that is the regulatory landscape, right? We have to take into account the uniform guidance, other federal laws, statutes, and rules, community development regulations, the universal notice, state law, and your local policy. We have to make sure that we are clear on whether we are engaging in a procurement action or if we are granting funds through a subaward to a subrecipient, and therefore not bound by the procurement standards that we're going to talk about. And we also have to make sure that we have authority. I'm going to mute for a second so I can really cough. Hang on. All right. So we are going to talk now about the procurement process under both state and federal law. If you have heard me talk about procurement before, you know that I like to talk about it as a puzzle, and specifically a Rubik's Cube. And the reason for that is there are essential questions that we have to ask and answer before we proceed with our procurement process. So these questions are: what is the authority for the expenditure? What is the source of funding? What is being procured? And what is the cost? So here in the context of CDBG-DR, we know the source of funding, right? But we also need to be aware of kind of the full mix of funding. Like I mentioned earlier, it could be that CDBG-DR is one source of funding, and then there are additional federal or state grants coming in to support a project. And so you need to know the full mix of funding for a project. We've already talked about authority as well. So I know that you will have done your research and talked with your attorney to make sure that you have authority for this expenditure, for this contracting process. We also have to know what it is that we're procuring. And that may seem like a simple question. And in a lot of cases it is, right? Are you sort of goods or services, right? That's what people typically think of when they think of procurement. But we have different types of services. We have construction or repair services. We have architectural engineering services. We have services that are sort of in a everything else category that aren't construction or repair and aren't architectural and engineering services, right? And so we really need to be clear on what it is that we're procuring to understand how to proceed. And then, of course, we need to know the cost. And the reason for that is both in state law and federal rules, we have thresholds that dictate what type of procurement process we're going to use, what type of procurement method we're going to use. So once we know the answer to all of these questions, then we can sort of move along. And like I said, the reason that I compare this to a Rubik's Cube is that you have to sort of solve, right, for all of these different questions before you've got the full picture of what your procurement's going to look like. So again, once we know the answer to those 4 questions, then we sort of move along to what is the procurement method. And when I say procurement method, what I mostly mean is, are we talking about informal bidding, formal bidding, qualification-based selection for our architectural and engineering services, or alternative construction delivery methods? Or is it some other process, maybe a competitive proposal for which we're using an RFP, right? So we've got lots of different methods that we can use, that we may be required to use, right? And so we'll figure out what is the procurement method, and then that tells us how we proceed step by step. So we answer these essential questions to figure out the procurement method, and then that tells us how we proceed with our procurement step by step. This is a visual representation of what our procurement methods look like under North Carolina law. So what you'll see at the bottom of this chart is for each of those arrows, the type of contract for which the procurement action is occurring. So we have purchases of goods, construction or repair, the Mini-Brooks Act, which covers architectural and engineering services and alternative construction delivery methods, and then this everything else category. So if it's not one of those 3 other things, it's in the everything else category. And so along the side there, you'll see the thresholds. And so the first threshold that we encounter is $30,000. And so that is for both purchases and construction or repair. Starting at $30,000, we have to do informal bidding. And informal bidding is essentially getting quotes and documenting those quotes. We get to formal bidding, which you can think of as sealed bidding, when we get to $90,000 for purchases and then $500,000 for construction or repair. Apologies for the coughing. I assure you that I am on the mend. I sound much better than I did yesterday. Yesterday I wasn't sure I would be able to do this. So thank you for bearing with me. Moving along, you'll see that for our Mini Brooks Act services, the A&E and then the alternative construction delivery methods, we have to procure for those starting essentially at zero. We do have an exception under state law, and I'll touch on that a little bit later. And then for our everything else category, what you'll see in the area is that state law does not require a competitive bidding process. So under state law, if you are procuring for what we call sort of general services, things like consulting services or custodial services, landscaping services, you don't necessarily have to follow a competitive process under state law. Now, your local policy may require you to do so, and as I'll touch on later, the uniform guidance does require you to competitively procure for services, but state law does not. All right, so that's a quick look at state law procurement thresholds and types of contracts. Under the uniform guidance, we have kind of three basic categories of procurement methods. We have informal, formal, and non-competitive procurement. And so in our informal category, we have what the uniform guidance calls micro purchases and simplified acquisitions. And so micro purchases, as you'll note in the kind of first bullet point at the bottom, micro purchases are defined by their threshold, which as a default is $10,000 under the uniform guidance. But a local government can self-certify to a higher threshold, and I'll talk about that on the next slide. Simplified acquisitions are any procurement that is above that micro purchase threshold, which might be $10,000 or self-certified higher, up to $250,000, unless a lower threshold exists under state law. All right, so under state law, like we just learned about on the last slide, we have a lower threshold for purchases that require sealed bid. So that means if we're sort of following the most restrictive rule, as we know we're supposed to do, our simplified acquisition threshold for purchases, if we are using federal funds, is actually $90,000 because we have a lower threshold established by state law. So this gets complicated very quickly, and we're just talking about purchases, right? So this is why you need to make sure that you have a sort of grasp on both state law and the uniform guidance that we're talking about here. So those are informal procurement methods. We also have our formal procurement methods, and that includes sealed bids and competitive proposals. Sealed bids are going to be used primarily for construction and starting at $250,000. Competitive proposals are used when sealed bid is not appropriate, is what the uniform guidance says. And so that's going to be typically sort of an RFP used for some type of general services. There's also, under the competitive proposals section, language about qualification-based selection, similar to our state law for architectural and engineering services. And I'll touch on that in some upcoming slides as well. The last category is what the uniform guidance calls non-competitive proposals. And I like to think of this as exceptions to competitive procurement. And so I'm going to save those to talk about in detail until the end of this particular session. So that is the uniform guidance. What may have already jumped out at you is that under state law, we had the thresholds of $30,000 for purchases and construction and repair, and then $90,000 for purchases when we get to formal, $500 when we get to construction. Here, under the uniform guidance, not only do we have some different names that we call the types of procurement, but we have different thresholds. So that micro purchase threshold is $10,000. So if we're under that $10,000, we are not required to do a competitive process. Once we get above that micro purchase threshold, then we have to get quotes. So we could be getting quotes starting at $10,000, whereas under state law, we're not required to get quotes until we get to $30,000 for purchases and construction and repair. And then our simplified acquisition threshold, if we're talking about construction, At $250,000, we're doing a sealed bid process under the federal rules. That is a lower threshold for sealed bid than we have under state law. All right? So your head might be spinning at this point. Do not worry. I have a slide upcoming that kind of lays out these differences for you, so you don't have to be, writing this down, furiously scribbling. I'll talk about this more. Okay, so now I want to talk about increasing the micro-purchase threshold. Thanks, Sean. So I mentioned that the micro-purchase threshold is a default $10,000. And so local governments can self-certify on an annual basis a higher threshold that is consistent with state law, and they can increase it up to $50,000. So it's got to kind of comply with state law, and they can self-certify up to $50,000. We know, of course, that state law imposes competition, getting quotes starting at $30,000, which means for purchases and construction or repair, a local government can self-certify this micro-purchase threshold to a higher amount, that higher amount being $30,000, through some pretty simple processes. And that is going to simplify your life. Because we don't have a state law on general services and requiring competition there, that self-certification go all the way up to the maximum of $50,000 for services. So this is a decision point for you all in local governments to figure out whether this is something you want to do. And so we have some information on the School of Government's website about that self-certification process, and we have a sample self-certification document. So I have that linked here, and you will be getting these slides after today's presentation. And so you can take a look and see if that's something that your unit of government wants to consider doing. All right, I want to talk a little bit more about the uniform guidance, kind of the key expectations under the uniform guidance. So I've given you sort of the lay of the land in terms of the procurement methods, but there are a lot more to the procurement standards than just the methods. And so we find most of these expectations in 2 CFR 200.318. One of the primary expectations is that full and open competition is mandatory, right? And for those of you who practice in procurement, this should not be news to you. This concept is sort of embedded in our procurement statutes and procurement principles. But the uniform guidance comes right out and says it. And then it tells us instances that are that the federal government deems restrictive of competition, right? Another sort of important point that we'll spend some time talking about is that you must award contracts only to responsible contractors, right? And this sort of relates to our standard of award, lowest responsible bidder that we'll be talking about later. And so we'll spend some time exploring what we mean when we say responsible contractors. I have one highlighted here in red, and if it's not already obvious to you, when you see this text in red, bold, italics, I want you to know that that's really important. And what this one says is contractors that develop specifications, requirements, statements of work, or invitations for bids or proposals must be excluded from bidding on that work. And I have a little thumbtack there because I want to put a pin in that. It is a very important concept, and we're going to come back to it later this afternoon when we talk about conflicts of interest, because it's essentially a conflicts of interest provision. You have to maintain proper documentation. Rebecca touched on the importance of documentation from the CDBG sort of HUD perspective. If you've dealt with federal funds before, you know that documentation is critical, and the uniform guidance emphasizes that. There are a few other provisions. The uniform guidance does place an emphasis on sort of interlocal agreements and partnering for strategic sourcing, and there is limited use of what we call time and materials contracts, just given the complexities of managing costs under those contracts. It's not a total prohibition. There are some ways to navigate using a time and materials contract, but they are disfavored under the uniform guidance. So as promised, here is my quick chart giving you a look at when the most restrictive rule comes into play, either from uniform guidance or state law. And I have here in parentheses applying the most restrictive or specific rule. And the reason I have that in parentheses is that there are some cases where one of our sets of regulations, more often the uniform guidance, just doesn't say anything about a particular procurement standard. So an example of that is where we need to publish notice of a solicitation and for how long. The uniform guidance just doesn't say anything about that time period or place for publication. State law does. It tells us very specifically where we need to publish and for how long for our formal procurements. And so it's not the case that state law is more restrictive, like it imposes more days, it's just more specific. And so I want you to sort of expand your thinking on applying the most restrictive rule. So what we're talking about here is applying the most restrictive or more specific rule. So the instances where the uniform guidance is more restrictive, I've already touched on this, but we know that under state law, we do not have competition required for procurement of general services. The uniform guidance does require competitive procurement above the micro-purchase threshold for those general services. Ooh, so sorry. So another instance where the uniform guidance is more restrictive is that we have that default micro-purchase threshold that I talked about, $10,000, is lower than that North Carolina informal bidding threshold of $30,000 for purchases and construction or repair. But don't forget that it can be increased. Another instance where the uniform guidance is more restrictive than state law is that formal sealed bidding threshold. It is $250,000 for construction or repair, which is lower than our North Carolina threshold of $500,000. And last but not least, I'll touch on this in some upcoming slides later, there are fewer allowances for non-competitive procurement under the uniform guidance than there are under state law. So that sort of is a quick look at where the uniform guidance is more restrictive than state law. Now let's flip over to the other side of the slide and talk about instances where North Carolina law is more restrictive than the uniform guidance. So as we've already touched on, the sealed bidding threshold for the purchase of goods is $90,000 under North Carolina law. That is lower than the simplified acquisition threshold of $250,000 that we find under the uniform guidance. We also have what we call the 3-bid minimum for formal construction or repair contracts under state law. We do not have an equivalent requirement under the uniform guidance. We have procedural requirements for historically underutilized businesses for building projects of $300,000 or more. And those requirements are more specific than the socioeconomic contracting requirements that we find in the uniform guidance. As I mentioned in my example earlier, the formal bidding statute in North Carolina requires a place and time for publication of those solicitations, and the uniform guidance does not. And one last thing here where North Carolina law is more specific is that the governing board is required to approve formal procurement contracts, but that can be delegated for purchases. It cannot be delegated for construction. So, quick look at instances where either uniform guidance or North Carolina law is more restrictive. All right. So with all of that in mind, I want to sort of walk through a particular project that could be funded by CDBG-DR, and sort of talk about the procurement process, thinking about how we apply the more restrictive rule as between the uniform guidance and state law. So we are going to look at a sanitary sewer line project for the city of Coatesdale. The city of Coatesdale has been awarded nearly $1.5 million for a sewer line project. During a recent hurricane, the sewer lines and manholes suffered damage, and in combination with their age resulted in severe inflow and infiltration. There was a large amount of rainfall that saturated the ground, and there was joint damage and degradation, causing sand and debris to leak into the system, and wastewater and sewage to leak out. And one of the lift stations in the system was forced to exceed its capacity, and due to the presence of that sand and debris has worn out kind of prematurely. So they've got a lot on their hands that they need to sort of shore up here. And so they are working on a scope that includes what you see here on the screen, replacing the sewer lines, replacing the manholes, lining those sewer lines, and then manhole covers, and replacing any paving that was sort of disrupted during this process. So that is their sort of general scope. And so they also want to rehab the damaged lift station, which will sort of support a LMI area, and they will also install a new emergency electrical generator that's going to support that LMI service area. So that's the sort of project that we're going to talk about, and we're going to look at a procurement process with this in mind. So hopefully a few things are kind of popping up in your head here. First, we are talking about construction, and we are doing construction in the formal range here. Certainly our formal threshold for uniform guidance, $250,000. Our formal threshold for state law, $500,000. We are way above that. So we are doing formal bidding for this project. And so we can just go ahead and get started, right? Well, not so fast. There are a few pre-procurement considerations to keep in mind, and we need to touch on those before we issue our solicitation. First and foremost, you have to have a conflict of interest policy, and you have to have a procurement policy. Rebecca touched on these earlier. These are really, really important to have a written document that reflects the conflict of interest standards and the procurement standards that we find in the federal rules, as well as state law. So you got to have those policies. If you don't have those policies, we can work with you. Other partners can work with you to sort of get those developed or get those current. We have some links at the end of this presentation as resources. All right. So now we've got our policies in place, our conflict of interest policy, our procurement policy. Now we're ready to procure, right? Well, let's talk about what the procurement would look like for this particular project. So we're talking about a sanitary sewer pipe project. The most common way that we proceed with construction procurement as public agencies is what we call design, bid, build, right? And so the reason it's called that is because we start with design. So we have to hire an architect or engineer who's going to draw plans for the eventual project that's going to be constructed. And so we're going to use qualification-based selection, the Minnie-Brooks Act, and we'll talk more about the details of that in some upcoming slides. We're going to use qualification-based selection to procure our designer. We're going to draw those plans, and then we're going to bid out those plans. We're going to inform the universe, hey, we're looking for somebody to build this project, and contractors will hopefully respond and tell us how much they will charge us to build this sanitary sewer project. So that is the bidding part of design, bid, build. And again, we're doing that by sealed bid because we are above the simplified acquisition threshold here with our CDBG-DR funds. And then the final phase, of course, is building the project. So this is, again, a traditional construction delivery where we've just got design, bid, build, design handled separately from the bidding of the construction work. This is sort of the life cycle of a CDBG-DR construction project, right? So we have, we start with our NOFA, our Notice of Funding Availability, and there's certainly more that happens along the way to get to project completion and closeout, as you can see here on the screen. But two things in common here, design, right? So we had design, bid, build, starting with design, and here on the second row, we have architect and engineer procurement. So we're going to start there in terms of our procurement process. We're going to assume that your project, right, the Coatesdale gets its project selected, approved, they're ready to go, and so they can go ahead and procure their architect and engineer. So we procure architectural and engineering services using what is called qualification-based selection. And the way that we do this, the sort of procurement vehicle, the solicitation vehicle, is what's called a request for qualifications, or an RFQ. And so what we are requesting, right, is that firms provide us with their qualifications. We tell them, hey, we want to build this sanitary sewer project, kind of do these improvements, and they give us their qualifications. And so then you all in local government as a subrecipient, you are receiving those qualifications and selecting the best qualified firm without regard to price. And that without regard to price is a really important aspect of qualification-based selection. So a lot of times when people think of public procurement bidding, they think of lowest cost, right? In this context of soliciting design services, architectural and engineering services, price cannot be a factor for evaluation. You cannot ask for it, and the designers cannot provide it. Now, there's some qualifications there, or maybe caveats is a better word since we're talking about qualification-based selection. You can ask for unit price, meaning firms are going to respond to you and say, look how qualified we are, and here's how much the people on the team that we're assigning to your project, here's how much they charge on an hourly basis. That is acceptable. But they can't tell you, here's how much our team members cost, and here's how many hours we expect it's going to take us to draw these plans, because simple multiplication would get you to an estimate of cost, right? So we just want to avoid anything that gets us close to estimating price for the work to be done under the RFQ. So in terms of advertisement, what we know is that you as a subrecipient simply have to announce these requirements publicly. There's no specific time or place required for the publication, but of course you want to have a wide pool, and so it's to your benefit to advertise in lots of different places. But state law and the uniform guidance don't tell you where you need to advertise. After you have selected that best qualified firm from among the firms that responded, you are going to negotiate a fair and reasonable fee with that best qualified firm, right? So sort of a two-phased procurement. We're sort of seeking qualifications, evaluating the best qualified firm, and then once we've done that, then we are negotiating price with that firm. If those negotiations fail, you can proceed to the next best qualified firm. So that is sort of where we start in terms of procuring architectural and engineering services with this particular project. We have a state law that requires A&E services for certain types of public projects. I'm not going to rattle this all off here, but you can see this chart sort of breaks it down when specifications will they are required to be drawn and sealed by a licensed architect or engineer. A couple of warnings on A&E services. So I have listed here on the screen 2 different citations. The first one is from the Uniform Guidance. The second one is from state law. So I'll talk about them in turn. What the Uniform Guidance says in 2 CFR 200.319 is that contractors that develop or draft specifications, requirements, or states of work, or invitations for bid must be excluded from competing on those procurements. You've already heard me touch on this. I will be talking about it more. But the thing that I want to point out to you is that we do not have an equivalent state law prohibition. So if you're new to the realm of uniform guidance and federal funding, you may not be familiar with this prohibition because we don't have a similar prohibition in state law. But this is a really important one, and we'll be talking about it some more. Kind of on the flip side of things, we find in state law an exception to qualification-based selection under the Mini-Brooks Act. So under state law, if you are procuring A&E services and the estimated fee is going to be less than $50,000 for a specific project, you can exempt that project from the Mini-Brooks Act if you exercise it in writing. We do not have that same exception under the Uniform Guidance. And so you cannot use that exception necessarily when federal funds are in the mix. So kind of compare and contrast there, state law and Uniform Guidance as relates to A&E services. All right, so now we've got our designs in hand. Now we can go out and solicit, right? Nope. There are a few more things that we have to do. So there are several more steps needed before we solicit. We have to perform a cost or price analysis. We have to go through our socioeconomic contracting considerations, and we have to obtain Davis-Bacon wage determinations. So I'll talk about these first 2 in some detail. The Davis-Bacon piece we're going to save until after lunch. So a cost or price analysis, this is something Rebecca touched on, but the sort of basic principle behind a cost or price analysis is that the federal government wants you to understand before you go out and solicit what a reasonable price might be for the goods or services that you're soliciting. And that's fair, right? And so this is just part of you being a good steward of public funds, which I know you will be anyways, but this is required of you. So performing this cost or price analysis, this is going to be required for every procurement transaction above the simplified acquisition threshold. You remember we talked about that threshold earlier, sort of default $250,000, although it's lower for purchases. And so just want to sort of make that clear on the thresholds. But once we reach that simplified acquisition threshold, then we are doing a cost or price analysis. And so a price analysis is typically going to be used for sort of off-the-shelf commodities. And what you're doing is sort of research to figure out what's the sort of going rate for this thing that I am purchasing, right? Maybe you've purchased it in the past, and so you can look at past contract prices, account for inflation. You can look at other units of government solicitations and contracts. You can look at catalogs, right? You're just trying to get a sense of what's going to be the total cost of the contract for these widgets. And so it's pretty straightforward. You do that research, come up with that sort of independent cost estimate, and then go through your solicitation process and figure out whether the bids that you receive back, whether they are reasonable based on that initial independent cost estimate that you performed. The cost analysis is a little bit more complicated. So the cost analysis is typically used for construction, and it's also it's going to be used for A&E services, essentially anything that's not those off-the-shelf commodities. And so it's not looking at the total cost of the contract, but kind of a more in-depth examination of the component parts of the contract. So for construction, we have things like labor, materials, right? All the different things that go into the cost of construction. So breaking that down and doing that in-depth research on all of those components to figure out what's going to be reasonable cost for those components. So it's kind of a two-step process. You're developing that independent cost estimate prior to soliciting bids or proposals. That's a really important point, that you have to do this before you go out with your solicitation. And then once you've done your solicitation, you're going to compare those offers that you get back from bidders or vendors against that independent estimate and determine whether it is a reasonable cost or price that you have been offered. So pretty straightforward in some ways, although of course a cost analysis is a lot more complex. And so we have a blog post that kind of outlines all of this process and includes some cost or price analysis templates. I've linked it here on the slide and it just popped up on the bottom of your screen, hopefully. So we've got some resources on that. So that's one of the things that you need to do before you go out to solicit. You also have to do what's called socioeconomic contracting. We find this in the uniform guidance, and what this particular provision says is that when possible, the subrecipient should ensure that small businesses, minority businesses, women business enterprise, veteran-owned businesses, and labor surplus area firms are considered for contracts. And so this section was modified. I mentioned that the last time uniform guidance was updated was October 1st of last year. This section was modified. This used to be a requirement, so the language was a little bit stronger. But now this is more of a sort of, when possible, we encourage you to contract with these types of businesses. Another modification that was made here was the addition of veteran-owned businesses. So in previous versions, veteran-owned businesses were not included. And so what does it mean to consider these types of businesses? Well, uniform guidance goes on to explain kind of different things that you can do to consider these types of businesses. And so things like including them on solicitation lists, and kind of soliciting them directly when they are potential sources for the work. There are 6 sort of ways in which the uniform guidance says that you can consider these types of businesses. So you have to do this before you go out for solicitation. If you practice in contracting in North Carolina, you probably, when I'm talking about socioeconomic contracting, you are probably also thinking about hubs. So here in North Carolina, we use the term historically underutilized businesses, sort of synonymously with MWBEs, Minority Women Business Enterprises. And so we have a state statute that applies when we have a building project costing $300,000 more if there are no state grant funds in the project, or it applies when the building project costs $100,000 or more if there are state grant funds in the project. And what this statute does is it requires local governments to take certain actions to encourage participation by historically underutilized businesses. I'm not going to go into a lot of detail here. This is a fairly detailed statute, but hubs are defined by state law, and essentially when we're talking about a hub, a historically underutilized business, businesses that are eligible to become certified as hubs are 51% owned by members of statutorily identified groups and managed in their daily operations by one or more individuals in those statutorily identified groups. And those statutorily identified groups include Black, Hispanic, Asian American, American Indian, female, disabled as defined in state law, and disadvantaged as defined in federal law. So we have these hub requirements that require local governments to do goal setting, make their own good faith efforts, require bidders to make good faith efforts, and report all of this activity to the hub office. All of these requirements, the reason why I'm bringing these up is that these requirements are more specific than the socioeconomic contracting considerations that I just mentioned under the uniform guidance. The one thing that I will note is that veteran-owned businesses is not a category under our hub statutes. And so that's one difference between the two. But if you are dealing with a building project complying with the hub statutes, then you have very likely met those socioeconomic considerations that we find under the uniform guidance. All right. I have popped up here on the screen whether this constitutes a building project. This project that we're talking about for the town of Coatesdale. And the reason for that is you can see the language that I've got here on the screen. These hub requirements apply to a building project. This is sort of a term that is open to interpretation. And so if you have a question about how your local government interprets the term building project and therefore how hub requirements apply to a particular project, that would be a question for your attorney. Okay, so that's it for our pre-solicitation requirements. We've talked about having that procurement process or procurement policy in place, having a conflict of interest policy in place, going through those socioeconomic considerations, and doing your cost or price analysis for this sewer repair. Now you are in fact ready to solicit. And so what you'll need to do is understand how to advertise this project. I've alluded to it earlier that the uniform guidance doesn't tell us where or for how long we need to advertise, but state law does. And so in our formal bidding statute, we learned that we have to advertise our formal construction projects in a newspaper of general circulation, or we can advertise these projects electronically in lieu of newspaper advertisement if we take certain steps. And I'll talk about those on the next slide. But we've got to advertise it, and we have to advertise it so that 7 days lapses between the first day of advertisement and bid opening. So we're really sort of talking about 9 days there. 7 days lapsing between the first day of advertisement and the date of the bid opening. And the advertisement has to include where the specification can be obtained if there's time restrictions on that. Has to include details about the bid opening, and it has to reserve the unit's right to reject all bids. So you're going to advertise this project. Town of Coatesdale wants to do this sanitary sewer project, and hopefully then you will get some bidders. So this is a decision point for your unit of local government, whether to do electronic advertisement. Now, I will say that this can streamline the publication process. And so if you want to advertise electronically in lieu of the required newspaper advertising, you can do that for a specific project or for all formal construction projects. Your governing board is going to have to enact a resolution to that effect. And so we have a sample here for you. So in terms of receiving bids back, you're going to be having that public bid opening, right? And you've advertised the time, date, and place for this public bid opening. You have to receive bids sealed, and they have to be received by that deadline that you put in place. Bids for construction or repair work are going to have to be in paper form. So you're going to be receiving sort of hard copies of bids. We don't have authority in North Carolina to receive electronic bids for construction repair work. Those bids are also going to need to be accompanied by a bid bond in the amount of 5% of the bid. And so some units of government will use a 2-envelope system where the bid is in one and the bid bond is in another. And so it's pretty obvious up front whether we've got the bid bond. But that's just a choice that local governments make. It is not required by statute to do a 2-envelope system, but you do have to have a bid bond accompanying these formal construction projects. And of course, bids have to be opened in public. We're having a public bid opening, and that's a requirement we find both in state law and the uniform guidance. I've mentioned this as well, but I'm going to elaborate on it here. We have a 3-bid minimum for formal construction or repair contracts. And so what that means is For this particular project, this sanitary sewer project for the city of Coatesdale, they have to receive 3 bids up front in order to proceed with the procurement process. If they don't, what this statute tells us is they're going to have to re-advertise, and if upon that second re-advertisement they receive less than 3 bids, but presumably more than at least 1, then they can select the lowest responsible bidder and proceed with the procurement process. But upon that initial advertisement, they've got to get 3. There are a couple of bid defects that I'll talk about on the next slide. Bid defects are essentially mistakes that bidders make that do not allow us to count a bid towards that 3 bid minimum. And so you can see here on the slide, if the bid is late or if it doesn't have the bid bond, we do not count it towards the 3 bid minimum. And the reason for that is just sort of a matter of the language that we find in the statute. But if the bid defect or the mistake by the bidder is any of these other defects, you can count it towards the 3 bid minimum. But to be clear, you can't consider that bid, right? Because it was not responsive. And so you're still going to have to reject the bid, but you can count it towards the 3 bid minimum and move along with your procurement process. So really important to know these details. This is a really handy slide to keep around. Assuming we've got 3 bids, we're ready to roll. Then we have to evaluate the bids and choose the lowest responsible bidder. And so what does that mean? So I've got it broken down here on the screen. I'll talk about it in a little bit more detail. But first things first, I think lowest cost is pretty obvious, right? When we're talking about responsiveness, we're talking about the bid itself. So did the bid meet our legal requirements and our bid specifications? So legal requirements, an example of that is that 5% bid bond, right? If they didn't provide 5% bid bond, you can't consider that bid, right? The thing that I like to tell folks is, if it's a legal requirement that we find in our general statutes, your local government is not the General Assembly, and you cannot modify the general statutes, right? So legal requirements are legal requirements. You also have to make sure the bid has met your bid specifications. So a silly example, let's say you are procuring a fire truck and you need a 50-foot ladder on that fire truck, and a bidder comes back to you and says, the best we can do is 10 feet for a ladder. That doesn't meet your bid specifications. You asked for a 50-foot ladder, right? So that bid is not responsive. Responsibility deals with the bidder themselves. Do they have the skills, abilities, and resources to do the job? This is going to be especially important in construction contracting, where it's a sort of, what I like to call a long-term relationship. You want to make sure that over time they're going to be able to fulfill their obligations under the contract and perform the project. All right, so once you have selected the lowest responsible bidder, you are now ready to award the contract, right? So we've determined who the lowest responsible bidder is, and now we want to award the contract. Uniform guidance doesn't say anything about how this happened, but state law does. So what we find in our statutes is that for formal contracts, both purchases and construction repair, those have to go to the governing board for award. Purchases, however, can be delegated to someone within the administration, but the board cannot delegate its authority for awarding construction or repair contracts in the formal range. What that means is this particular contract for the sanitary sewer repair for the city of Coatesdale is going to have to go to the Coatesdale City Council, which means you got to plan for that agenda cycle and make sure you're accounting for that in your processes. Another part of the contracting process, performance and payment bonds. So you are going to obtain performance and payment bonds from the contractor for the work. Once you are at the stage of awarding the contract, you're going to then move into sort of contract execution. And one of the things that you need to know is that for your construction projects, you are going to be obtaining performance and payment bonds from your construction contractors. And this is a requirement that we find both in state law and uniform guidance, and I have the citations here on the screen. But these bonds serve two different purposes. So the performance bond, of course, is covering the costs of performance of the project, the completion of the construction work. And so that is for the protection of you in local government as the owner of the project. And then we have the payment bond, which is intended to cover the costs to be paid to subcontractors. And so both of these bonds need to be in 100% of the contract price. And we have a little bit more specificity in state law. What it says is that for projects costing over $300,000, these performance and payment bonds are required for 100% of the cost of each contract costing over $50,000. And the reason for that specificity on the contracts over $50,000 relates back to the ways in which you can contract with a prime contractor or with trades. And I'm not going to get into all of that. You just need to know that if you have a project over $300,000, and certainly our City of Coatesdale sanitary sewer project is over $300,000, then any contract involved in that project that's $50,000 or more, we need a performance bond and a payment bond for 100% of that contract cost. We also have an additional requirement that we find in state law that that bond has to be executed by a North Carolina licensed surety. And that information is a little bit tricky to track down, but you can find it through the Department of Insurance. So you want to make sure that it's a North Carolina licensed surety issuing those bonds. All right, so that's kind of the gist of what that construction project is going to look like in terms of procurement, getting all the way from our pre-solicitation requirements down to sort of execution of the contract. I don't have a slide on execution of the contract. I'll tell you that uniform guidance and state law do not tell us who in local government is required to execute the contract. Typically, that is a responsibility that's delegated to a manager, might be assistant managers through some policies, right? But you want to make sure that the appropriate person is signing the contract and binding your unit of government to that contract. All right, so this slide here is sort of a summary of everything that we just talked about, kind of looking at it through the lens of uniform guidance requirements, state law requirements, and kind of the overlap of the two, right? So what we've talked about here is that when you have a federally funded construction project, you have to comply with the uniform guidance, and in this case, also HUD rules and requirements that we find in the uniform notice. And you also have to comply with state law. So some of the requirements that you see here on the screen come from uniform guidance. Some of them come from state law. There are some overlaps between the two. And so this is what it looks like. There's a sort of light blue box that says the UG, meaning the uniform guidance. And so in that light blue box, those are the uniform guidance requirements that relate to this formal construction project, right? So we're doing that sealed bidding starting at $250,000. We have to do the cost or price analysis. Those two requirements at the top of the list are specific to the uniform guidance, right? Those are instances where the uniform guidance is more specific or more restrictive. Then kind of moving down the list, we have overlapping requirements of the uniform guidance and state law. So that bid bond that it has to accompany the bid when it's submitted is something we find in state law and uniform guidance. Like we just talked about, performance and payment bonds also required by state law and uniform guidance. And then the hub requirements for building projects, like I mentioned earlier, uniform guidance lays out socioeconomic contracting considerations. And under state law, we have the more specific hub requirements. So if you are complying with the hub requirements for building projects, you have also complied with those socioeconomic contracting considerations, except for veteran-owned businesses. And then the last three on the list are specific to state law. So we know the uniform guidance doesn't have an explicit minimum number of bids, doesn't tell us where we need to publish our advertisements and for how long, and doesn't tell us anything about who has to approve the contract. All of those requirements come only from state law, which is why there's not an overlap there between the blue and the green boxes. So this is, again, kind of a summary of everything that I've just talked about as it relates to that construction project in the formal range. I want to mention just a few more things that we find under state law in regards to construction contracts. One of them is that when licenses are going to be required for a construction project, we need to put that into our solicitation, into our specifications. And so one of the big ones, of course, is general contractor licensure. And so we find that in General Statute 87-1. But what we know from that statute is that general contractors have to be licensed by the board that licenses them when we have a construction project costing $40,000 or more. So certainly that would be the case for this City of Coatesdale sanitary sewer project. We also have the ability under state law to withhold what's called retainage. And so this is just a portion of the payment due to the contractor under the project, under the contract. And so this statute allows for that retainage to be withheld for any contracts over $100,000. There's a formula in the statute, kind of as the project progresses, there's less that you're able to withhold as the owner, but that is a possibility and can be a helpful tool in contract management. A couple of other things, construction notice in writing. This is just a requirement that where public construction projects are going to be occurring next to property owners, we have to notify them in writing. However, if this project is discussed basically in a public meeting, that bypasses the need to do this construction notice in writing. And last but not least, if we're talking about a building construction contract, so involving a building like this one that I'm standing in here, we have to include in the contract, in that construction contract, dispute resolution process. That has to be in the building construction contract regardless of cost of the contract. So there's not a threshold there where that kicks in as a requirement. It applies to any building construction contract. And that dispute resolution process can mirror the dispute resolution process that has been adopted by the state construction office, or if a local government chooses to create its own dispute resolution process, it has to include mediation as a step along the way. So construction contracts, if it is not clear to you already, require a lot. And you know, the most money in terms of Commerce's CDBG-DR allocations is going towards infrastructure by just a hair, but that's why I wanted to focus on an infrastructure project here. So construction projects are complex, both sort of in their execution and of course from a procurement perspective. So we've talked about what's required there. I want to make a mention here of alternative construction delivery methods. So you'll remember earlier, before we had our break, I touched on design, bid, build, the sort of traditional construction delivery method. We also have authorized in our statutes what are called alternative construction delivery methods. And those are specified by statute as construction manager at risk, design, build, bridging. We also have public-private partnerships, but that's kind of a different ballgame, and so I haven't included it here, but it is technically grouped with these alternative construction delivery methods. All of these types of alternative construction delivery methods are required by state law to be procured using qualification-based selection. You'll remember earlier that we talked about qualification-based selection for our architectural and engineering services. And so the important components of a qualification-based selection process are that we are asking for qualifications and we are not asking for price, right? So that's kind of the gist of qualification-based selection under state law. The uniform guidance also allows for, sort of requires qualification-based selection for the procurement of architectural and engineering services. And so really similar process under the uniform guidance for architectural and engineering services. But a big difference between state law and uniform guidance here is that the uniform guidance requires price to be solicited for services other than architectural and engineering services. So to say that a little bit differently, under the uniform guidance, A&E services, architectural and engineering services, are to be procured using qualification-based selection process, the qualification-based selection process, and we are not asking for price. If it's something other than A&E, you have to ask for price. And so the uniform guidance goes on to say that qualification-based selection cannot be used when services provided by A&E firms are a potential source to perform the work. So if you have an A&E firm that might be performing the work, you can't use qualification-based selection. So it's pretty clear here that if we're not talking about A&E, we can't use qualification-based selection. We can only use qualification-based selection for A&E under the uniform guidance. But state law, like I just talked about, requires us to use qualification-based selection for these alternative construction delivery methods. The uniform guidance does not seem to allow us to use qualification-based selection to procure a CMAR, a design-build firm, or a design-build bridging firm. And so we have an inconsistency here under the uniform guidance and state law that I think is irreconcilable. Either we ask for a price or we don't. State law says we don't, and uniform guidance says we do. So this came up during sort of the days of ARPA, and the General Assembly passed temporary legislation that allowed for federal funds to be used for these types of alternative construction delivery methods, and sort of to comply with, allowed local governments to comply with the uniform guidance when procuring these methods. And so that was an attempt to sort of align these two different regulatory schemes. But I think at this point, it's not clear, right, that a subrecipient, you all, can comply with both state law and the uniform guidance. And so what I would say to you is proceed with caution and consult your attorney. I'm happy to hop on a call with your attorney if that would be useful. But this is just sort of a word of warning on these alternative construction delivery methods. One other sort of procurement piece that I want to leave you with is competitive proposals. So what we were talking about with the City of Coatesdale was one type of formal procurement under the uniform guidance, the sealed bid process. There's another type of formal procurement allowed for under the uniform guidance called a competitive proposal. And this is really going to be probably RFPs, requests for proposals. And so what the uniform guidance tells us is that this process can be used when the conditions for sealed bid are inappropriate. What does that mean? I think primarily what this is getting at is there may be times when price is an evaluation factor that you want to consider, but it's not the sort of determining factor for making your selection. There may be other criteria that you want to use to select your contractor or vendor, and so this gives you that flexibility to do so. And so if you want to use a competitive proposal process, you have to provide public notice of your solicitation, and in your solicitation you have to identify the evaluation factors that you're going to use and how they may be weighted, right? If you're giving some factors more importance or value than others. And you have to have a written method of conducting the evaluations and making selections. So I think this is pretty standard when we use RFPs, that we want to communicate to potential proposers how we plan to evaluate them, right? And so the uniform guidance is saying when you are using a competitive proposals process under the uniform guidance, you have to do that. You have to identify those evaluation factors and the weight that they're going to be given. So that's the gist of competitive proposals under the uniform guidance. The last procurement standard that I want to leave you with here is documentation. So Rebecca touched on this, but I don't think there can be such a thing as too much documentation in the world of federal funding. You may have heard the saying sort of like pictures or it didn't happen, right? You can think of that with documentation. Documentation or it didn't happen. You have to make sure that you have documented your procurement process from beginning to end, right? Why we chose this method, how we determined the successful bidder, where's our contract, right? All of these things need to be documented as part of your procurement process. And then additionally, the regulations, the HUD regulations for the use of CDBG funds also have certain record maintenance standards that are linked here and that Rebecca talked about earlier. All right, so that is kind of the procurement puzzle. There's one more piece that we need to discuss, which are exceptions to competitive procurement. And then we'll be done with procurement and we'll move on to cross-cutting federal requirements. So the thing that I want to emphasize to you is procurement is important, right? Competition is important. Our statutes really encourage competition. Cases involving procurement disputes emphasize the importance of competition, right? We talked about earlier, one of the most important kind of federal procurement principles is fair and open competition, right? Competition is important. So I want you to keep in mind that non-competitive procurement is the exception, right? It is, if you are intending to contract with a vendor without using competition, you really have to make sure that you are adhering closely to the parameters of the exception and that you've sort of crossed your T's and dotted your I's, right? What I have here on the screen is a depiction of the overlap between the uniform guidance allowances for non-competitive procurement and our state law exceptions for competitive procurement. So what you'll see is in that blue bubble, which is on my left-hand side of the screen, there are 5 exceptions to competitive procurement under the uniform guidance. There are many, many more exceptions to competitive procurement under state law. The 2 that we find in both uniform guidance and state law are single source and emergency or exigency if we're looking at sort of FEMA language. So we have all of these exceptions, but when we are involving federal funds in a contract and we want to bypass procurement, what we really need to be focused on is that blue bubble, right? The state laws that allow for competitive procurement exceptions, those exceptions don't necessarily show up in the uniform guidance, which is to say there could be an allowance under state law for an exception to procurement, competitive procurement, that is not allowed in the uniform guidance, right? So just because it's allowed under state law does not mean that we find the same exception under the uniform guidance. You're going to have to look to this blue bubble and see if you can use an exception. So single source, an emergency or exigency, I'm going to talk about these on some upcoming slides since there's the overlap there. I'm going to talk about the ones that we find exclusively in the blue bubble. So micro purchases, we talked about the micro purchase threshold being $10,000, but it can be varied upwards. Anything that is below that micro purchase threshold is what we call a micro purchase, and you don't have to go through competition. You can just contract directly with a vendor so long as the costs are reasonable. You can also bypass procurement if you get written approval from the federal granting agency. That is not very common. You should not rely on that as a possibility. I have regularly seen it happen, but it is provided for in the uniform guidance. There's also an additional way to contract without competition if competition is deemed inadequate. So how do you know if competition is inadequate? Well, you probably have to try competition first to figure out that there's no competition available. So those are the ones that we find exclusively in the uniform guidance. Now we'll move on and talk about emergency and sole source or single source. So we find emergency exceptions under state law. I'm going to talk about this because the language under the uniform guidance is fairly similar. But under state law, the emergency exception can be used for purchases and construction repair contracts in both the informal and formal ranges, so starting at $30,000. And this exception applies when there's a special emergency involving the health and safety of people or their property. And we have case law that tells us that the emergency has to be imminent or existing, not just generally anticipated to occur in the future. Now, where's that line? That's sort of anyone's guess, but that's something that your attorney can help you think through, right? Because if you are bypassing competition, like I mentioned earlier, you need to make sure that you can justify that decision, both under state law and the uniform guidance. To exercise this exception under state law, governing board approval is not required. And of course, the uniform guidance doesn't make any mention of whether governing board approval is required for any of the non-competitive procurements that I mentioned. We also have language regarding emergencies under the Emergency Management Act, which is what we find here in Chapter 166A. So there's a broad definition for kind of what might be deemed an emergency under the Emergency Management Act, but sort of similarly to the procurement statute that I referenced on the last slide, an emergency must involve actual or imminent threat of widespread or severe damage, injury, or loss of life or property. The General Assembly a couple years ago modified the language of the Emergency Management Act to add what is known as a supply chain disruption emergency. And so this is where there's a significant threat to a local government's ability to acquire products or services required to provide or restore essential services such as electricity and water to the general population. So if your local government wants to make use of that exception, the supply chain disruption emergency exception, your governing board is going to have to get involved, and they're going to have to adopt an emergency declaration regarding the supply chain disruption. The city of Gastonia has done this for some of its utility components, and so I've linked here on the screen their emergency declaration if you want to take a look at that. So that's kind of the landscape of emergency under North Carolina law. And of course, under the federal rules, it just talks about emergency very generally. And so it's going to be up to the federal agency to really sort of give guidance on what we mean by emergency. And we've seen, of course, FEMA, through its public assistance program, has sort of this expansion of emergency to also consider exigency, right? But here, of course, with CDBG-DR, we need to consider how HUD considers emergencies. My guess is that this is not really going to come into play with the funding that you all are handling for CDBG-DR, because this is really a planned program. You're making application, right? And so these are not emergencies that we're dealing with, but I just want you to understand this piece of the procurement puzzle. We also have, in the overlap of our bubbles, sole sourcing or single sourcing. And so under state law, we know that this applies to purchase contracts in the formal and informal range and allows a local government to legally bypass competitive procurement when performance or price competition for a product is not available, when there's a product available from only one source or supply, which I think is what most people think of as single source, or standardization or compatibility is the overriding consideration for the procurement. One note here, under state law, if you are choosing to use this exception, governing board approval is required in order to exercise that exception. So those are our exceptions that I wanted to touch on. I want to leave you with a few resources. Like Rebecca mentioned earlier, the partners sort of behind this training, we are all here for you. Of course, I'm situated at the School of Government, so I am providing you with some of the School of Government's procurement resources So we have a uniform guidance procurement policy. It's a sample policy. We have a federal and state procurement chart that sort of compares the different aspects of the uniform guidance and state law. We also have a most restrictive rule summary, and we have blog posts about procurement and a sample conflict of interest policy. So we have a lot of documents already available, and as these programs progress, we'll be working with the partners that you see at the bottom of the screen to continue to develop policies and samples that will assist you all as you make application to the CDBG-DR programs.